but it's not going to work, so we won't do that. I'm Mandy, for those of you who haven't met me. Next to me, I've got Lynette.
Hello, everyone.
So we're going to talk to the first couple of sections today, and then Lance Peterson off our team, he's going to come in also talk a wee bit of today. So we've split today's session into 4. So at the moment, we've got you all on mute and all your videos off, so you can turn those on and off as you wish to. On the right-hand side, you've got chat, so if there's any questions, pop those through, and one of us will be keeping an eye on that as well for any questions that come up. So as we go through each section, there'll be an opportunity at the end of each section for any questions that people have got. So first couple of sections today, really on the HR front, looking at just how do we keep people with us in these very uncertain times, keep them engaged and productive. Little bit looking at creating employment opportunities. Lots of questions getting asked around should I or should I not recruit at this stage. So we'll have a quick look at that. Lynette's going to talk through a little bit around what's happening in the world of leave. Mile made some announcements during lockdown around its packages, so we'll just have a look at what are those issues and challenges and things to be thinking about in-house. And then Lance is just going to cover off some of the recent cases of interest that have been coming through the Employment Authority, and a couple of those are around wage subsidy, so they're well worth tuning in for. So hopefully everyone's in and it's all okay. I'm going to flick over onto share screen and we'll just work through the presentation. It's much easier to have some slides and you can read with us as you go, so hopefully this will all work. And it lets me play what we want to play. So if we just jump into the first section for today, and that's around how do we keep people with us. It's a really uncertain time, is about the only word that we can put on it at the moment. And what we know is that pretty much everybody has some form of uncertainty, questions going on in their lives. So this slide just sort of flags out all the different kinds of things that are going on for people, whether that's you as business owners, as HR, leaders, and as employees. So huge amount going on, and we don't know how this is going to play out yet. So it's being really mindful around, it is a uncertain time. None of us have been here before. I think fair to say there's a whole lot of COVID fatigue right now. But it's really working on actually what's in our control right now. And I said to the group yesterday, one of the videos that came out during lockdown was a message from Sam Kane to our drought farmers. And it was really interesting sort of listening to some of his messaging around his comeback from his neck injury. And he talked about the small steps and focusing on what's in control, and that's what got him back into the All Black team. And I think that we sit with that is actually what's in our control. What can we be doing? What can we be thinking about? So we translate that into what can we be doing with our staff and keeping people with us. So we call that what's in our control. So we are just going to launch through this today. So thinking about what's in our control, the first step is what we can be telling people. So communication is the key to so much of what we work with when it comes to people. And so we start there and we end there. So telling the story. This is something we've talked about along the way in some of the blogs that we've done over the COVID time, is not everybody's with us all of the time now. Some people haven't come back to work, some people are back in lockdown, and I appreciate we've got some people joined us from Auckland today. So how much are we telling people? Tell the story. What do they know? From there, how are we engaging with people? So if we want people to be productive and engaged and motivated and still with us, doing their best for us, how are we involving them, engaging them? What questions are we asking them? So lots of tools to do that. You can have meetings, debrief sessions, you can run your surveys, but really talking to people. So this is a time where communication is more important than it's ever been. So another thing that's in our control, we can still have fun. So a little bit hard in Auckland at the moment, but for the rest of the country, absolutely, we can still have team and social activities. So one of the things we really missed over the lockdown was that office environment, what we call the water cooler chats, and actually just having fun. So when it gets all a bit serious, that gets hard work after a while. So making sure we do stop, take the moments to celebrate. Another thing that's still in our control during these times is promoting training and development opportunities. So no need to take finger off pulse. If there are things that you can be doing, whether that's on the job training, whether it's having resource coming in, people going out to study, that can still happen. And making sure that we still make that happen. So the next two is the resources available for staff and for businesses, and making sure that those are promoted and accessed, and making sure that you utilise what's available to you. And I've got that on the next slide, we'll come to that. And finally, communicate again. So it's something that you'll keep hearing us talk about as we go forward from here with the blogs and news that we will share with you. Is just that importance of communication. So much of what we're seeing at the moment in the problem issue area, communications are fundamental in that. So in terms of keeping people with us, doing the best that we can in the times that we're in, is making sure that we're well aware of what's actually available out there and maximising our use of that. So I've just picked the big ticket items here today, and do get in touch if you need to know any more about any of these or anything else that might be available. But I'll just quickly run through them. So work and income, that is your go-to website for everything to know about subsidies and payments. So that's wage subsidy, wage extension subsidy, income relief payments, leave payment scheme that's in place at the moment for people who can't work, who would otherwise work. A huge resource for many businesses at the moment is the Regional Business Partner Network. That is nationwide, and that's available for any company that is GST registered, and there are different funds within that. So COVID-19 Advisory Fund, that's for up to $5,000, 100% funded advice for accounting, marketing, wellness, HR, and business advice. There's 5 core areas. Providers right throughout the country. They have a management capability scheme, which is about developing capability in-house. The Callaghan scheme, which is about innovation, and I'm sure there's a myriad of other schemes. So make sure if you're GST registered that you're aware of what's available to you there. So just in terms of where we sit, we are a registered provider for the COVID-19 Advisory Fund and the Management Capability Fund. So we can certainly help with how that operates. COVID19.gov.nz, that continues to be the go-to website. That's the government central website for everything COVID-19. There's a couple of sections that I've pulled out here to be really aware of in terms of support for yourselves as businesses as well as for your staff. So the financial support section has every bit of information about financial support for business. So that's from loans to subsidies to payments to all the different things that government has done for business. So good central go-to place. Really important in there, and I can only encourage people to absolutely go and have a look at this section in there, is around health and well-being, and particularly in mental health space, so mental well-being space. There's a huge number of tools, resources, apps, information and guidance. Because we're sitting in uncertain times, we don't know how people are responding and reacting, and sometimes we don't know until it's down the track and wish we'd nipped things a little bit earlier. There's some very fantastic tools, and it's making sure your staff are well aware that those tools are there. So I've had the Mentenia app downloaded for a couple of weeks now. It's great, sends you a little message every day and reminds you about the basics of life and things to remember to do. And that's just sometimes just a good reminder that life is still here. So we'll carry on from here. Tools and resources, the other area is, engage with your chambers of commerce, your business hubs, your professional associations if you're a member, your banks, your accountants. So if you're looking for resources and wanting resources, don't be afraid to tap into your services around you and just say, hey, what should I be thinking about here? Because there is a wealth of support. Key message from us is just don't feel alone. It's a challenging time, and it can be challenging, particularly if you're at the top. So just reach out as you need to reach out on that. So just to close out, sort of keeping people engaged and productive and with us, go back to sort of the communication space again, because that's fundamental in that. These here, and we'll send out these slides, are just some really good back to basic questions to be thinking about in terms of, you know, who are my people with me? So think through, how much are you communicating with your people? How much do they know? How much more do they need to know or would benefit from knowing? What feedback are you getting back the other way from your team? What are your staff challenged by? What are things that they can think about at work? What do they want more of at work? What other support can you be offering? So can you tap into some of those resources available and be sharing that with your teams, making people aware of what's out there? I was with an insurer yesterday who had been out and was doing a lot of work again around that KiwiSaver space. It's really heightened that again. So, you know, don't be afraid to broaden out what can be done for staff. And a real biggie here, as attendees in this session, is what other support do you need as owners, as leaders, as HR people in the business? So thinking about yourselves as well amongst all of this, what do you need? So that's just a very light touch just on keeping people engaged. I don't know if I can get back here at the stage, out of here, to see if there's any questions. Without, I'll just jump in. If anybody's got any questions at this point, do you just want to unmute and throw those in the mix before I move on? No, right. So I'm going to skip through this pretty quickly, just so Lynette can cover off, Leave and Lance cover off case studies. I won't get told I've taken all the time. But this one's really come about because I've had a couple of clients sort of really questioning, should they be recruiting? What does that look like? Is it safe to recruit? What's timing looking like? So first question I'll always ask is, what's the why? You know, why are you looking to recruit? What's the need? And it could be that it's just delivering on the now. Actually, it's fundamentally still pretty busy out there with a lot going on. It could be about vacancies. It could be about the fact that you have got some business plans in place, that you're trying to take that longer term focus and need to start now to make sure that you're ready to deliver on what you want to achieve. It could be that you're thinking about succession planning. So starting to look at what is the demographic and profile of your workforce. What do you need to be thinking about? So really good to keep asking those questions all the time. Have I got enough resource for now and for what I want to achieve going forwards? So keep asking that question. In terms of thinking about, do you start to proceed now or do you wait for a bit further down the track? It's thinking about what are the challenges around us at the moment. There are actually still some pretty big challenges out there in the recruiting world. First one being still challenge around just suitable candidates. We were in a skill shortage before we went into COVID. That hasn't changed. I've not seen any evidence of lots and lots of people coming back to New Zealand that are going to fill the skill gaps that we've got. So that's an ongoing challenge. The ability of your own resources to train and retrain people. So thinking about timing, actually, who's going to onboard people, who's going to mentor, who's going to develop, how does that look, how do you go about that? A real biggie is, depending where you're located, viability of candidates actually being able to relocate. So here in Hawke's Bay, huge housing shortage, very little for sale on the market, very little available for rent. So fantastic to be able to advertise and think, great, let's bring people here. Big question of logistically, how feasible is that? So hopefully spring will start to see a bit of movement in the market. And the big one that's starting to really face many businesses is immigration challenges. So we've heard immigration repeatedly say recently they offer no apology as their starting line. So they've put a new level in for essential skills visa. $25.50 an hour is the minimum rate now to get a visa for more than 6 months if you're needing to support an application for a visa in that space. So lots happening there. The accreditation scheme for employers is due to be coming. We haven't seen sight of it. I think we just flag at this point that immigration isn't going to be an easy option for a little while yet. So on that basis, we've got to think reverse from that. What have we got here in New Zealand? What can we do? So if we think about the options, again, this is just simple overview. There'll be lots of other options. But the first bit is, are you doing everything you can to make sure you keep your good staff with you? So that word communications features there again. Keeping people progressing and developing in-house. You know, are you having performance reviews? Are you having performance conversations? You're sharing your business goals to people understand how they can contribute to that, how they can develop and support what you want to achieve. Are there opportunities to broaden your workforce? So where you've got a core workforce, is there the opportunity to have contracting relationships or partners that you can be sharing work with or collaborating with? So real opportunity at this stage to say, how are we working and are there opportunities to work in different ways? So not being afraid to be open to options. And then the one that the government obviously is really pushing to see at the moment is bringing new people to sectors. So how do we retrain the easy group to pick on Air New Zealand staff? They're not going to obviously relocate within their sector. So they're going to be reliant on other people taking a chance on them and providing opportunities. So back to basics, you know, how do we bring people into industries and into sectors? So re-looking cadetships, internships, apprenticeships, work experience, lots of titles to put on at the junior level, and then looking at pathways from there. So it's if you're looking to recruit, what level? If you can't recruit at that level, what are the different options available to you? And there'll always be options. So again, just to close out this section, just some questions to really be thinking about in business right now. So thinking about if you're recruiting, what's the minimum you need? So if you can't recruit a like for like, what do you need? What does that look like? Behaviour is really important amongst that. The old adage of recruit for attitude, train for skill. Thinking about how you can assess potential talent. So if you are recruiting from other sectors or industries, what can you do to assess underneath? So it could be simple numeracy, literacy testing right through to some work experience-based testing to see is there an attribute there that you can work with and develop from there. Another one is who can you engage to help you find talent? So you've got lead searchers available on the market, you've got your recruitment agencies, look at what resources you've got in-house. So lots playing in the recruitment field that can absolutely help right now. Application numbers are up and significantly up on where they've been. So, you know, capacity to work through advertising is challenging. Thinking about how you can upskill existing staff. So can you be moving people up through the ranks and create junior level opportunities? What's available to you to do that? And again, some of that's that government resource in terms of what support can you get. Government's put a lot into the apprenticeship space in particular. So are you eligible? Do you fit in the criteria for that? The other one is how you communicate your job opportunities. So Seek and Trade Me still big areas that people are recruiting through, but they are reliant on people looking in that particular timescale. So it's a fairly narrow pool that you have available to you through Seek and Trade Me. So using social media, using LinkedIn, using search and recruitment agencies, and starting to think about sort of different ways you can connect with community, depending level of job. You know, whether you start to connect through church networks, community notice boards, so having to think a little bit outside the square at the moment. But key fundamental in it is, if you're needing resource, think about what's holding you back, consider of that. Is that valid? What if that's valid? What can you do to shore yourself up? Making sure that if you do recruit, you've got good up-to-date employment agreements in place that have got good protection, so if this pandemic does continue, you know you're going to be protected going forwards. But I wouldn't say that that's going to be a barrier to being able to recruit right now. So it just becomes fundamental. So fly through that, but any questions before I hand over to Lynette just to talk about some of the challenges with leave? And just unmute your microphone if you've got questions. Oh, right, I'll hand over to Lynette.
Hey, good afternoon, everyone. So I'm going to touch on leave. So just to recap where things are at, you'll recall back in 2018 there was the announcement that there was going to be a task force set up to have a look at the Holidays Act and to come back to government with some recommendations around some changes that would achieve some simplification, make things easier for the Holidays Act to actually be able to be put into practice. So where that is up to, as far as we're aware, is that the working group have reported back in October 2019 to the then Workplace Relations Minister. But since then, not a lot appears to have happened from our perspective. Anyone is still yet to see that final report that was done. It seems not a lot seems to be happening in that space. So what that also means for us then too is that any changes that are likely to come out of that review are likely to be a number of years away. So in the interim, the challenges around the Holidays Act for employers still continue. And those challenges are, I think, are pretty well understood by people now. So you will have also been aware that during the lockdown period, actually, MYOB came out and they released some software updates to the payroll packages that they had under their umbrella. So that's quite a few payroll packages. And what they've done there is that they have made some changes where it's now going to be possible in those MYOB packages to actually manage annual leave in weeks versus hours. But there are a number of things that you do need to be very aware of as part of that process. So MYOB have produced some very good guidelines and some good checklists to make sure that you work through properly and thoroughly before you actually go turning on that functionality within those payroll systems. So in preparation, you will definitely need to have made sure that you've got very clearly defined what represents a working week for employees. Now, if that is actually going to mean a change to what the employee's current employment agreement is, please note that you will need to go through and do a variation with people to make sure you get that in place first off. One of the very next core points is that you do need to make sure that your starting balance for annual leave is correct. So there's one common thing here that people will often get wrong, and that's where somebody, if they've had a change to their working week pattern, so a common one is somebody moving, say, from part-time hours through to full-time hours, or in reverse, from full-time hours back to part-time hours. You do need to actually go through in systems where annual leave is recorded in hours. You do actually need to go through and make a manual adjustment to the number of hours of leave entitlement that may be sitting there for an employee. So that's not about the accrued leave, that's leave entitlement. And that's because you need to be sure that the leave has been recorded correctly in terms of that common denominator of a week. So when they were working on, say, 20 hours a week as a part-time employee, and if they had a balance of leave entitlement of, say, 2 weeks, which when they were a 20-hour person, that would equate to 40 hours. When they move up to full-time employment, at the time that they move up, you still need to make sure that they have a balance of 2 weeks. So that 40 hours balance that's reflected in their entitlement needs to actually be changed to 80 hours. Now, this is a common area where people are not necessarily aware of that, and you will need to go back through history for people that have had changes to their working pattern week to make sure that that's actually been reflected correctly. The other thing also too to check before you go turning on the functionality to be able to move through into weeks is to have a really good solid look at people who might be down as variable hours people. Please have a really good look at that to make sure, are they truly variable hours, or do they actually have quite a core pattern of work? If they do have a core pattern of work, then you need to be able to reflect that in their payroll setup and to be able to go back and reflect that properly in their employment agreement as well. As well, before you go turning on any of these changes and actually hitting the start button, make sure that you test your payroll data very thoroughly in your test database. Run those good reports, make sure that the balances are correct. Do some trial changes, make sure that it's actually calculating correctly as well, not only for annual leave, but also too for any relevant daily pay calculations for leave such as sick leave, bereavement leave, public holidays as well. And the last step too to make sure you do well is communicate any changes that might be occurring regarding this with the employees. So they don't get a surprise, so they don't then get their pay slip and think, what on earth is this? This is different from what it was last week. Get ahead of that curve and certainly discuss that really well with them. Please make sure before you do go through making those changes, if necessary, talk to your accountant, talk to your payroll support people to make sure that this is all in place and working well. So what I want to touch on next too is just some common themes that we still see occurring where people are commonly getting the Holidays Act interpretation wrong. So these are just some of the things that we see on a regular basis. So the first block I want to talk about are common problems that we see around annual leave. So one of the first things that we see often is payment for annual leave still not occurring correctly. So the thing to bear in mind there is that when annual leave is actually paid, when it's taken, it is the greater of the average of their last 52 weeks earnings or their ordinary weekly pay. So it's which is ever the higher. So if you've got somebody who is doing overtime on a fairly regular basis, or they might have been paid some commissions, they might have been paid some bonuses, there's every chance that the average of their last 52 weeks earnings is going to be the higher value than the ordinary weekly pay. So you should see that increased. The next thing to be aware of as well is that annual leave in the Holidays Act is measured in weeks. It's not measured in days or in hours, it's measured in weeks. So it's a very core thing to have in the back of your mind. And that week definition is what it is at the point of when the leave is taken, not when the leave is earned, but when the leave is actually physically taken is what matters. And that comes back to that example I gave of when somebody changes work pattern and the need to actually adjust it in the payroll system to show that they're now in a new pattern, that their leave entitlement value is now different. Also too, when people take that leave, you need to have agreed with them what the portion of that week actually represents for the leave they've taken. So an example is if, say, somebody is a 3-day-a-week person, but if they work different hours on each of those 3 days, you need to discuss with them and agree up front what is the portion of that week, how are you going to reflect that when they take a day's leave? Is it going to be just a straight 1/3 of a week, or because those hours are different, is it based on a different number of hours that are taken? Leave entitlements to be adjusted, I've already covered that off. And the last thing I wanted to talk about under annual leave as well is just a bit of information. The accruing of leave that you see in payroll systems and that people will see on their pay slips, it's an accounting function. It's not a legislative requirement. So nowhere in the Holidays Act do you actually see referrals to accrued leave. So that's just something to bear in mind as well. So the next sort of lot of common watch outs to think about is in the area of sick, bereavement and domestic violence leave. So the unit of measure there is days. So that's quite different from what it is for annual leave, which is a week. This is days. So a common thing that we do surprisingly still see quite often is that people will somehow think that the 5 days of sick leave, for instance, which is allowed for under the Act, people will think of that as a week. And so if they've got a part-time employee, they will then in their mind be pro-ratering that back. That's not correct. So the Holidays Act talks about sick leave, for instance, as a measure of days, 5 days. So it does mean if you have a part-time employee who only works 1 day a week, they are entitled to still have 5 days sick leave. So that's something just to bear in mind. The next thing is that in terms of payment for sick, bereavement and domestic violence leave, the go-to default payment, and the one that you must always look at first, is relevant daily pay. So relevant daily pay is what that employee would have earned had they have worked, had it not been for the fact that it was a public holiday, or that they were sick, or that they were on bereavement leave. That is the go-to default. The use of average daily pay is something that can only be used if RDP cannot be determined. So you do need to think about that as well in the back of your mind. And it's a good practice to get into if once you have made a decision around what the relevant daily pay for that person should be, what would have they earned had they have worked, to put notes in the payroll system so that if you're ever challenged on that, you can go back to that day, you've got your rationale as to how you came up with a conclusion that that was a day that had it not been for the fact that they were sick, they would have actually worked 10 hours on that day, or they would have only worked 8 hours on that day. You can put that rationale in the system. The other thing to be aware of as well that we see commonly people not putting in place is that casuals do have an entitlement to things like sick leave, bereavement leave, domestic leave, if they meet a minimum time worked criteria. And that minimum time worked criteria is an average of 10 hours per week, along with at least a minimum of 1 hour per week or 40 hours per month over a 6-month period. So that's something as well to bear in mind. So your casuals may have entitlement to this type of leave as well. The next common thing where we see people going wrong is in the pay-as-you-go area. So that's where you're paying out the 8% of holiday pay as people earn their wages on a payday basis. That typically applies just to casual employees, but you do need to be sure that those employees are still truly casual, particularly in this area. If you get that wrong, if they're not truly casual and you have been paying out their holiday pay as they go, you will still have an obligation to provide paid leave after that 12-month period that they've been employed by you. So you can end up paying twice if you have not got that employment status correct. So one good thing to do there is to keep reviewing your casual employees to make sure that the hours that they are working is truly as and when required, and that there are no ongoing expectations in terms of hours. And I wouldn't expect to be able to look and see casual employees showing up on a roster, for instance. You would expect those people to be coming in on almost on a day-by-day basis when they're needed and required. So keep checking to make sure that your casuals are actually truly working under that set of that type of arrangement. If they're not, it's probably time to have a look at changing their style of employment agreement. And another thing to be aware of is please make sure you keep accurate records. That includes all your leave records, and it includes all of your hours worked records. And you also should be keeping hours worked records even for your salaried employees if they are doing variable hours of any kind. So if you're a salaried employee they might only be set up on a 40-hour basis, but if they are coming in doing extra time, you do still need to keep an eye on what they are working and have those records available so that you can demonstrate that you are meeting minimum wage requirements. So if anyone has any questions, please feel free to unmute your microphone and ask me any questions. Okay, so we've got silence, so I'll hand it over to Lance. Thank you.
Good morning, everyone. So I'm talking on cases of interest today. About 5 cases I want to look at. The first 2 are cases that revolve around the COVID-19 situation and the lockdown and the payments that were made. Both cases are similar in that the employer applied for the wage subsidy, paid the wage subsidy and topped up the wages to 80%. They differ where one is brought under the Wages Protection Act, in other words, in regards to deductions that were made from the wages, and one is made under the Minimum Wage Act. Right. So the first one is Regret versus Dove Hospice. There was 6 staff. They were retail store managers and HR manager, a comms officer. Again, they received the wage subsidy. So on the 24th of March, they were told, we're going into level 4, we're closing the stores down, and what we're going to pay is we'll give you full pay through to the 29th, and we're going to apply for the wage subsidy. They did that, and the wage subsidy was approved, and so from the 30th of March through to the 22nd of April, they were paid at 80% of their minimum wage. During that period of time, Dove instituted a restructure by presenting a proposal and then confirmed it, and the positions were made redundant. What they did do is provide for an extra month's notice, so they were going to pay the 4 weeks out at 80% and then the additional 4 weeks the wage subsidy only, and the individuals weren't required to work during that time. The employees challenged the justifiability of the redundancy or the dismissal. That one hasn't been resolved and is still going. But more importantly, they say they did not agree to their normal wages or salary being paid at a reduced rate, or that deductions could be made from their wages. So I talked about the 20% was a deduction. Dove argued that the Wages Protection Act or their employment agreement was not breached. Rather, due to COVID, the employers were not ready, willing and able to actually work. That the employers were offered an extended notice period, which they also accepted. So the real argument here is were they entitled to 100% of their wages when they had not performed the work. So the ERA member said yes, they were, and provided the reasons. First reason was that there was no agreement between the employer and the employee to reduce wages. The employment agreement did not have a provision for suspension of wages or salary or non-performance in the circumstances faced by Dove in late March. So it's commonly referred to as a business interruption clause within your employment agreements. So if you've got one of our agreements, you'll find that clause in there. It was brought in after the Christchurch earthquake, but it'd be a good idea to have a check just to make sure it's there. That's the business interruption clause. So they hadn't agreed at the time, and there was nothing in the employment agreement that said the employer could do that. The next thing that the authority said is, if we're looking at the Wages Protection Act, then the definition for wages was, as I've got up there, salary or wages that include time and piece wages and overtime or other special payments agreed to be paid to the worker for the performance of services or work, and also includes any part of any wages. So the company was arguing, well, you didn't perform any work, so therefore we don't have to pay wages. The authority member said, well, actually that sentence, or that part of the sentence I've got highlighted there for the performance of services or work, that's a conjunctive. It comes at the end of the statement. So you can't rely on it. You have to look at the whole statement as a whole. So he was obviously a bit of an English teacher of some kind. I still try to kind of figure that out. But anyway, that's what he came up with. Finally, the authority member said that the workers were at all times ready and willing to work, and it was Dove's decision not to require them to attend work, particularly during that notice period when the lockdown had been lifted. And on the evidence, they were able to fulfil their obligations under the employment agreement. So what was the outcome? So they had to pay the 20% that they hadn't paid for the period where they only paid the 80%. For the extended notice period, where they only paid the wage subsidy, they had to pay the full 100%. And the ERA is still to hear the unjustified dismissal, the redundancy claim, and they've also yet to decide if, because penalties were requested, they've also decided to, yet to decide on whether penalties will apply, and there'll be a cost order as well. So the lessons learned is that, the government proclamation to use your best endeavours, and it was the best endeavours to get to 80%, does not trump the Wages Protection Act. So it was seen as wages, and the authority says you've made deductions from those wages. The alert level restrictions determined by the government that detail that businesses cannot open, or that people are instructed to remain home, it does not trump the employer being willing and able to work. So that was done on the papers. And I believe that one is being appealed to the Employment Court. The other kind of lessons you can take from that is that being sensitive and generous is not always legal, particularly in regards to that second part of the notice, the extended notice period. It was quite generous by the employer, but in being generous, they were being illegal by not paying full wages because they hadn't got agreement to do that. So the other lesson learned is if we go into close down again, our best advice would be to implement the business interruption clause straight away, then check for the eligibility for the subsidies, consult on variations to that agreement, and one thing you probably do in there as well is offer them the opportunity to take their leave. But very, very importantly, consider the unintended consequences if you're providing that extended notice period as well. The second case, this was a group of employees in Gate Gourmet New Zealand Limited, 130 in-flight catering staff, 40 hours a week, and they were on minimum wage. There was some work available, very little, but some work available during the close down. So they provided a proposal to partially shut down and the payment of 80% of normal pay, and they could use the annual leave to top up. So that was a proposal. Then they provided a notice for that partial close down, and they presented three options to the employees. They could take the annual leave until it was exhausted and then go on to the wage subsidy and a top up, or they could just receive 80% of their normal wage from that date forward, or be paid the 80% and top up with the annual leave. The union there said, look, they'd agreed to options 2 and 3, but not to people having to use the annual leave until exhausted. Then on the 3rd of April, the union said, advised the company, actually, you can't do that. You cannot pay below the minimum wage, i.e. the 100% of the contracted hours within the employment agreement. The authority, just catch up here, what the company said was, hey, in regards to their claim was that the old adage that there's no work, no pay. And even if there's only partial work, there is only pay. The union says, well, that only applies when the employee is withholding their labour, not when the employer is. Well, that was the court cases that had run previous to that. Even though the union had agreed to only paying them 80% of their wage, that was not something the union was entitled to do, because that was below the minimum wage, and you can't contract out of an act of parliament, which is what the minimum wage offers. So even though they agreed, they were not allowed to, and it shouldn't be used. The company, Gates, said, look, we've acted in good faith all the way through. We've relied on government advice and our specialist lawyers, and we had to do this so the business could survive and we could preserve jobs. It was a pandemic which had caused the problems and almost evaporated all of the work entirely. And essentially that they were not responsible for the state of affairs. In short, they accepted the government's assistance in order to protect employees rather than the entitlement to legally consider mass reductions. The authority found that they were willing and able to work. They had agreed hours and wages in the employment agreement, albeit minimum wage. That 80% was wages was not a gratuitous payment they were making. And you just cannot contract out of the minimum wage. So essentially the same lessons are learned here. I guess they reduced their wages below the minimum wage. If they'd reduced hours, then the argument couldn't be used that they were paying below minimum wage. So if they got agreement to reduce hours by 20%, there ought to be no minimum wage claim. So those are the two ones that have come out of the authority in regards to the COVID situation and employers using their best endeavours to get to 80%. These should be challenged. I know one is being challenged to the employment court. But at the end of the day, the authority is saying, look, don't really care about the situation at the time. This is what the contract says. So just the other ones that have come out of the court just recently has got to do with, there's three of them in fact, and that's why I'm bringing it up, familiar relationships. So the first one is Cohen versus Kidd. They'd been friends for near on 50 years. Mr. Cohen was receiving the government superannuation. Fortunately, his marriage broke down. Mr. Kidd said, hey, it's a good friend. Look, I'll give you something to live free of charge. Mr. Cohen started doing a bit of work for the, Mr. Kidd owned a truck driving business and a couple of other little businesses. Mr. Cohen gave him a hand with that from time to time. After about a year, Mr. Kidd gifted Mr. Cohen some land, probably at a value of about $80,000 at no cost to him. And the idea was that Mr. Cohen was going to construct a house on the property and live there. But that didn't eventuate, and after 7 years, Mr. Cohen and Mr. Cohen brought a claim of unpaid wages against Mr. Kidd for that 7 years. The court found that he was a casual type employee, and they awarded him wages and holiday pay of around about $106,000, $104,000. They also brought a penalty against Mr. Kidd or his company for not having an employment agreement and not paying holiday pay and statutory holidays. I think the legal costs are probably around about $50,000 to run a case like this in the employment court. So the court was saying, look, there was a familiar relationship there, but that was more of an employment. He was an employee. The next one was Dylan versus Tully Klein. So a father and son. So the son and his wife owned a little farm, and the father had nowhere to live, so he came and lived on the farm with them. I think it may have been a separate dwelling on the farm. The son also provided him a car and internet and free power, and that was all good. The son and the daughter-in-law, they were professional people and didn't work on the little farm. They had their own businesses, and what they did on the farm was what's called an adjustment arrangement. So they provided for a price somewhere for people to keep their horses. That it was a little business, didn't make any money, it wasn't financial, but the father must have been doing a bit of the work there. So the father brought a wage claim against the son, and in doing that, the court had to decide whether he's an employee. What the court did say was, well, this is a real familiar relationship, that it was a lifestyle that they were living, and so the state of the relationship, father and son, so there was no employment relationship there. And so the father was unsuccessful in the employment court. And I think probably this year the son's going to save a bit of money on Father's Day presents. The last one I just want to talk about quickly is Mackay versus Wanaka Pharmacy. He was a director and a shareholder, and they had married. During the marriage, she worked at the pharmacy plus another business. I think it was called the Wanaka Sun and the Wanaka Pharmacy. She got a company car and also had a fuel card. After the separation, she went to work one day at one of the businesses and was told that no, you don't. Someone else does that job now. Don't need you to do it. And the next day, she got a text from the lawyer saying, "You no longer work at either of the two companies." So she brought a claim, and they went through the test. Even though she could come and go as she pleased, she did do the payroll. And there were other things that they looked at. They looked at the fact that she had gone on parental leave. The husband argued, look, this was all to do with taxes and to bring our tax levels down by income splitting. It wasn't a real important relationship. However, the court turned around and said, no, it was. And she got holiday pay for 13 years, even though they'd been overseas annually. She got 13 years worth of holiday pay, and she got compensation of about $13,000. And that was that one. So it was really important to if you are a shareholder or a director in a business, but also work in that business, really important that you have those two separate agreements, one for the shareholder arrangement and one as an employee. So those are the cases of interest that have come out of the court with the authority in the last couple of months. I'll now hand you over. Any questions? A lot to take in very quickly. 5, 4, 3, 2, 1. I'll hand you over to Mandy.
A little circus in here today. Brilliant. So hopefully you'll all see me now. We've got some questions sitting on the side here. Regional business partner funding is not available for charities. Look, I still don't understand that one, but trusts and societies are specifically excluded. And I'm yet to find what funding has been made available for that sector. So certainly if anybody comes up with that, keep in touch with us about that. There was another question just back in the leave section. Sorry, we couldn't see these while the presentation was on. If you're cashing up a week's annual leave available from a prior year, would that be average weekly pay on the current year, last 52 weeks? So cashing up, I need to check that one. That's a really good question as to the higher of on that as well. I will, what's the best way to do that? That's going to get Lynette, our lead expert, and so we'll answer that question. So look, huge thanks for coming in today. Zoom is still very new to us, so any feedback, any suggestions of anything you'd like us to do differently with Zoom in the future, do keep us posted. And Lynette is just coming back to answer that question that came through. So cashing up a week's leave, is that higher of calculation?
Absolutely.
Yeah, so there's the answer there from Lynette. So back onto that leave section, if you're agreeing to cash up a week's leave from an entitlement for an employee, calculate that based on the higher of ordinary earnings or average weekly pay the last 52 weeks. Hopefully that all makes sense. So any final questions before we end the section today?